She's voting.
Yeah.
Okay.
We're live.
We can
We're
start.
on? Okay. This is the regular meeting of the Ethics Commission of the Town of Chesapeake Beach. We have a quorum, 2 members are present, and therefore we can proceed. Also present is the commissions and town clerk. We begin with the Pledge of Allegiance. Okay, first agenda item, approval of the agenda. Agenda has been distributed, and are there any objections, changes? No, agenda is approved unanimously. Next agenda item is the approval of the previous minute, which was on September 11 of this year. Minutes have been previously distributed. Are there any further comments about the past minutes? Approved. Next item, we have 2 newly appointed officials since the last disclosure statements were received. Ethics ordinance, they must now did submit their disclosure statements. We have those in the package that was distributed. There are only a few, and I think deal with them right here now. There are 2. First, there are 2 disclosure statements for officials who left since the last reporting period. That's Kubiak, the previous administrator, and 1 member of the operations manager. Both of them left in the course here. We used a simplified form for both persons, which merely states whether or not there have been substantive changes since the disclosure statement, and reported that two same. So Ms. Richard will be.
Chairman, before you do that, I think either Sharon or Holly mentioned that there may be an issue with one of the responses. And that is with respect to Schedule H, the relationship with government agencies. both of these individuals, or one of the things that you're supposed to report is the amount of money or other consideration that you received in the relationship. And amount of consideration from what, Karen, was it you or was it Holly who talked to me about this?
Brought it up.
Okay, is that the compensation for both those individuals may have changed with the new fiscal year. So while the report for the prior year may have listed X compensation, this next year, that's subject to this reporting period, compensation may have increased. So
I think we will have to look at the prior year's disclosure statements, see what they actually reported. I didn't save them in my own files. Or that the answers to that particular schedule give rise to some discussion at a previous meeting. There was reluctance by at least some of the files to whom that schedule applied. Objection to making that financial disclosure. And both of these persons, 22 statement to see whether their statement that my answers would be the same, whether that is still a proper responsive answer or whether it isn't. If hypothetically, if the original response had been I don't, as a matter of principle, don't disclose my compensation I receive from working for this town. And the answer which we have now would still be good. Or if not good, let me correct that, it would still be accurate. We would have to make require a numerical statement only if, in fact, the compensation had changed and if the compensation was numerically stated in the previous disclosure statement. Probably have that same discussion again when we are ready to sign off on the disclosure statement. The same schedule is still there. It contains the same question, which is given to us by the state. And the way this year's schedule is drafted gives the filer the possibility to sidestep a direct answer to that question.
And I would just say that it's up to the commission whether you want to accept these two statements as presented, both sides under the penalty of perjury, or whether you want to find, the statements.
Fred, I'm sorry. So you're suggesting that the commission can either accept these as they are or require the filers to verify or double check.
Well, what I
What are
would,
the options that,
the two options are, number one, you accept the both forms as submitted and signed under the penalty of perjury, or you conduct your own quote investigation. You have staff look at, do a comparison of compensation 1 year versus compensation next year, and report back to the commission, and then you won't. Typically, election day, generally you don't go behind the forms as submitted and under the penalty of perjury. Work with do not and will not go beyond or behind the statements made by the filer.
this particular question seems to be applicable to just about any future filing similar to this. And perhaps as a side, we need to take a note that maybe emphasize that if you had some reported income, you need to visit that particular item. But from what you're saying, it seems like clarify that item in the future.
I think that's the way you can proceed. I'm not sitting here saying that these are not correct as submitted. I don't know. I'm just raising an issue that the town administrator, brought to my attention before the meeting, saying, Fred, maybe there's an issue with respect to because of the possible change in compensation, during the year.
Compensation the previous year was for 12 months, and this would have been maybe for 9 months. So there's a potential for discrepancy. Yeah, I'm not sure, Peter, if it makes sense to us investigating that or just take these as they are and then make sure that in the future we clarify that that particular item needs to be looked at.
Well, for present purposes, trying to be pragmatic, I see no good reason to go back to Christian Kubiak and say, like our finger. So what purpose would be seen? I mean, the ultimate purpose of these disclosure statements is to prevent unethical such as self-dealing, conflict of interest, and so on. And, nothing that will suggest to us that the policy purpose of these disclosures is subverted by creation the following statement. When we get to connection. Sure. Back to that. Page is. And I concocted an instruction which would enable affected persons to avoid having to disclose for the town engineering company. They do work for a dozen municipalities, and I bet money if you say you have to list them all and state the revenue received from them. No, we don't do that. Then what do we do? But all this being said, derelict in our duty if we accept these supplemental statements
I don't
as
think,
written.
I don't think you would be derelict in your duty because these statements are submitted penalty of perjury, and I think that you have the right to rely upon the individuals who submitted them. If I knew and could say to you, they are wrong, that might be a different story, but I can't say that. I don't know if there's anything wrong with them.
All right, then. I make the motion that it is just the two of us.
Right, I'll make the motion.
We accept these and
Yes.
go on with life. All right. We also received the statements from newly appointed members, a newly appointed member of the Board of Appeals, and a new planning and zoning commission.
Chairman,
Yeah.
just that we take Ms. Everett's statement first.
Yeah.
I've had an opportunity to review it, and I would note that while she completed Schedule G on the list of schedules, she checked, no, the Schedule G does not apply. So I think that that's an error.
There was precedent for this. In the original review, there were a number of filings that answers to a particular schedule, but that schedule was not marked as applies. And what we did is mindful of the peril of perjury. We called these people in, met with Sharon, checked off the additional schedule. That's our past practice, and stick with it.
I didn't see anything else with respect to Ms. Everett's statement.
Everett. So Cheryl, would you go through the motions as in these other cases? Next time she is in the building, say, come here and check this off.
Yeah.
Let's turn to,
I've reviewed that. I would note that although she completed Schedule B, she did not have a check mark for yes or no in the list of schedules for Schedule B. One or two other things which I'll get to in a second. That is back to Schedule A, page 9 of 23.
well, I noticed she filled in Schedule B, interest in business entities, but didn't check E at all.
Well, hadn't gotten there yet. I was working from the beginning. Schedule A, not complete questions 8 through 12 on page 9 of 23, Schedule A. And whether she has to complete 12A, 12B, and 12C depends upon whether or not she
Transferred, yeah.
transferred. So that issue.
But in any event, she should be able to answer date of the property, when the property was acquired.
8, 9, 10, and 11, and even 12. All of those need to be answered.
Yes or no?
Then we come to Schedule B, page 11 of 23, question 6. She did not check off yes or no. Then whether she had to complete question 6A and 6B and 6C, depending upon whether she answered question 6 yes. I think that was it from my review.
But I was unable to note your comments
Okay,
on it. But if we can get for Sharon's benefit over it once more, or did you catch it all? Oh, okay. All right, so that there will be follow-up. Takes care of.
or B. Or B.
4B, correct. Move on to 4C. Big package, the revised disclosure statement. Everybody has seen previous incarnations. Have there is everybody, which embodies previous comments. Greg, as well as from council, I think. And version that we see here still has the same date, but further revisions, they show their line. I have no further comment on this. There are a number of stylistic errors and line spacing, indentations, marking of bullet points, and so on. And I think the consensus that emerged was that somebody with appropriate word processing skills clean that up. Because quite frankly, I tried and failed. And I checked with Sharon after that. Do we in this office have capability to get that done? And she said, yeah. I quote you correctly, Sharon.
Yes.
Mr.
So
Chairman.
I don't think we need to, I have a checklist which I'll give to you, which may not be complete. Any further technical corrections that should be made so we don't send them to Sharon or send them to me and I'll forward them.
Is this the most recent version that I sent you back after you sent the version out to everybody? Say,
It's what you sent back
I sent back to you,
to me,
and that you sent out to everybody.
and that I sent to everybody.
Okay.
And Sharon, will you be sending out after all the
Edits.
formatting and the like are done? Would you be sending the final copy so that we just take one last look at it?
Sure.
I think that would be nice to do after, because not knowing exactly what you have picked up as corrections. So we have one more opportunity to read through it, look at the formatting, and that would be the final iteration.
And hope that at this point we will be done with our discussion on item 4C. 4C. But maybe we should revisit schedule H. That is the schedule that deals with relations of government entities. And it includes the infamous question, describe the amount of money for the consideration.
I think that conversation we had earlier may not require a change here, but a change on the short form that they fill out when they leave the town. You know, to just highlight the fact that
Yeah.
on Schedule H, make sure that the amount that you have. So this is
Well,
what I'm suggesting is on this form. Sentence here, in particular, are there the amounts that were cited on Schedule H, have they changed in the? So that we don't have the same pending question that did they forget to look at the Schedule H or not? The conversation we had earlier about the departing members.
They say that they've reviewed the schedule.
Right, right, and I think that Holly picked this up, that could be potentially a common oversight, that they didn't look at that particular thing. So if it would help, perhaps we can add a sentence here just to emphasize in particular, if you had Schedule H filed in the prior year, make sure that the amount of compensation is the same or something. Does that make sense?
having to look at the 2022 or numerous dollar figures. Because, to the best of my knowledge, would do the same type of work.
My suggestion is not going back. My suggestion is for the future.
For the future, okay.
For the future, we add a clarification on that form to just bring it to their attention that if they had Schedule H in the prior year, that's an area to make sure.
Let's go over the note on Schedule H in the present version.
Okay.
And, looking for a way how Tyler would avoid having to answer this question number 4. You know, how much money did you? If the town knows what this town paid to Jakubiak and other professionals, don't know. Other municipalities paid. My concern nothing but somewhat related experience and paranoia. Wanted to create a loophole where somebody would not answer that question, not giving us numbers, and come up with some creative way to get around. And one of them, which doesn't seem optimal, somebody could say, let's say town council. About the town council can say, look, the town knows what my fee is or was. So it serves no purpose. It's already disclosed to the town. And yeah, other six municipal clients, it's a matter of confidentiality, and I'm not authorized to make that disclosure. Now, there's a footnote to this. Fred called my attention to it after they sent out the first version of this, that under the this is information which, if somebody actually looks at this disclosure statement, that could be redacted. Not just entitled, but I believe obligated to black out information that is essential. So that lets some of the air of my balloon. But still, I think we should avoid a situation where we say, you have not told us how many municipalities you for how many municipalities you provide engineering services. I think our engineering firm, we are hardly the only town that they do work for. Same thing. The successor of Jakubiak probably also does the same thing for others. That's his business. And same thing goes to town council. I think the appeals board has its own council. I think so. Yeah. And this illustrious commission, we have our own council. There might be someone else, at least three law firms. The particular person who sits in our meetings or in we have no problem saying, I'm perfectly willing to disclose what my fee is, but the firm itself, the person in most cases will have partners, will say, no, that's not information. You have to disclose it to the taxman, but you are not free to disclose it to anyone else. And by the way, we don't want client A to know what we pay to client B, because then there'll be a bidding war. And and that's a situation which we should not provoke. Suppose that this is a new, fairly recent addition to the not only to our ordinance, but also to the state mandate, which is based. Quite frankly, I don't understand. that others seem to see no problem with this. Whether you've spoken to one or more of your colleagues who do what you do for us, and I know you had lengthy discussions about a totally unrelated definition of what is attributable, which was difficult to understand.
What are the
But,
choices?
You know, I finagled that one. I simplified the question, and really with a procedural move, we have a question that has, do you have an interest in an entity that itself owns directly or indirectly through multiple stages and blind offshore trusts and such devices? If the answer is yes, then delegate someone, Mr. Farhad, go talk to them. Yeah, let's see whether he'll throw you out on the. And I don't think that particular thing will ever become practical. But this one here, the fee question, we must find a way that our professionals can answer it in such a way that this commission can say, okay, we are satisfied. One way to do that is if we say, they have a legitimate right to keep that information confidential, even though the town is already obligated to back out that information. The disclosures are distributed to the public, actually. I don't know how many people have access to these files. We know one person. Sure, Holly could look at it. Any council member could say, want to know who the people are that we deal with.
So it seems to me, Peter, the concern you're raising is the fact that most consultants or subject matter experts would be reluctant to disclose the compensation they receive from other jurisdictions because the form specifically says all the state entities and so forth and so on. And it would be troubling to do that. So it seems to me we can either, if it's possible and if it's within the commission's authority, to limit that question to the compensations that are related to the town, because this is the disclosure to town and the interactions with the town. what kind of compensation have you received? That seems to me that that would be one way, if it's possible to limit question 4 to the compensations with the town of Chesapeake Beach. The other, if that is not possible, then the concern you're raising really goes back to the ethics of the state, the mandate they had, right? To go and appeal to them to say that this is a trouble area. How can it be addressed? I guess the question to you, Fred, is that within our jurisdiction to say that we can limit question 4 on that form, on that schedule?
Well, Fred, while you are thinking, sure whether we could limit it, because there is no limitation. These questions are prescribed.
Well, that's my question. Can we?
We have to ask them.
And wording that's in here is the same as in the town ethics ordinance. I
Okay.
don't think you can narrow the scope of what the town council, in adoption of the ethics ordinance pursuant to state law, has mandated.
So what are the solutions to the concern that Peter is raising?
Well, also, if we limit it to the town, you know, I am the engineer, the zoning expert. So the consideration that you received the town of Chesapeake Beach, should say, what are you talking about? Town of Chesapeake Beach knows how much we paid you. So, here I am, the filer.
So what do you suggest,
So,
Peter? What do you suggest then?
Why do you want me to confirm? Look at this is total silliness.
So what do you suggest as a way to address the concern you're raising?
I mean, even if we could legally narrow the question like that, that would make the question itself pointless.
So, all right, fair enough. What do you suggest to be done?
Well, my suggestion is right here. We allow the filer to make a determination that is this information, am I free to just make this disclosure or not? Now, if we are dealing with a sole practitioner, then it would be more difficult for that person to claim privacy shield.
Well,
But most of them are operating in an organization which has its own ground rules. And I speculate now that if you're a member of a law firm, your partners or your superiors, whoever governing structure there is for your organization, it is their say whether or not they make certain disclosures or whether they allow you to make disclosures. And so, even taken into account that further disclosures by the town, by the recipient of this information, would be prohibited, to be stricken out. it weakens the protection, the privacy protection argument.
I think your argument, I understand your argument and the concern. Frankly, regardless if I'm a sole proprietor or part of a law firm, to disclose all the compensations that we get from all the jurisdictions in Maryland, that would concern me
Yeah.
on many levels. So the point is well taken. The question is that what can we do about it? Are there thoughts that you have to address that, or maybe we should ask Fred if there are any ways to address that, because you articulated the point very well, the concern.
Basically, we pass the buck to the responder. Assume two cases. In one case, there are no privacy concerns. You know, I'm in a law practice with one partner, and he says, "Go ahead, disclose. I don't mind." The second case is the partner says, "Oh, I do mind, and these are the reasons why, and there are good reasons, you know, like all businesses, consulting, engineering, and so on. It's a competitive business, and there are certain things that you don't want your competitors to know, find out, and also say that in that situation, it doesn't give me sufficient comfort to know that if the town hands this information on to someone else, which could be anybody in town, anybody in the world, because these are public documents, even though they can be, the federal people, they have a word. I don't think it's redacted. Maybe that is the.
That's the
You black out a word or a sentence or the whole document. They do this all the time, laughing.
Let me throw out something else on the table. That is, what would you think if I were to prepare just a brief amendment, proposed amendment to the town ethics ordinance that would limit the scope of this to the town and not not government, local government entities generally, and sentence that off to council, to the ethics commission, state ethics commission, say, "Well, what do you think about this? Do you think this would fly?" Yes, well, then we can go back to council with an amendment to the be approved or by the ethics commission, and it narrows down the scope of disclosures to what's really of concern to the town and the people in the town, the relationship of this individual with the town, not the relationship of this individual with other political jurisdictions who we really are not within our scope of authority or review or anything like that.
Is that not exactly the purpose of the recent legislation? That they do not narrow it. Any government identified and
So, but because of the concerns you have raised, both in terms of competitive nature of whoever works in that field, as well as, frankly, the information about other clients. So if I have a contract with several towns, I'm not sure if I want all the towns know how much I'm getting paid from other ones either.
Well, but remember, I think all that's public information anyway. I submitted a public information request to 5 towns and said, please provide me documentation of the fees that you pay to your town attorney or city attorney in calendar year 2022.
So you can obtain that.
Huh?
You can obtain that through Freedom of Information Act. Okay, so that's public information. If that's the case, as a practitioner, do you have a concern to fill out this
I don't know,
form?
I really haven't.
Given a thought. So I think that actually puts a little bit of a different shade on this issue if that information is public information already, and we are just asking for them reiterate that here. The difference should we? Well, what would be? I mean, one suggestion you had is go through the process and see if we can limit this to the interactions with the town. And of course, if we went that route, then it also begs the question that Peter raised, if that's the scope of this schedule, then do we really need to ask them how much you got compensated, because the town knows how much they were compensated. So then within that revision, then it begs the question, does the question 4 stays on the form or gets eliminated? Because it does then look kind of silly.
I don't have an answer to your question.
That's fine.
You have to remember this at the state level was put together to deal with much bigger, problems with questionable ethics of state officials and dealing with state government agencies. Not, and somehow because state ethics law says that every local jurisdiction has to have an ethics ordinance. Similar to the state ethics commission said, okay, this is what that means. I think it might be worth the exercise, not talk about very much time, put something together formally to the ethics commission. I think this would fly.
That's a good next step.
Seems like you have some reservation about that. I'm not wed to it. I'm just trying to.
Right.
Can the state ethics commission issue advice?
Fact is what you're doing informally, right?
Getting an informal read, because if we were to, if we put together a proposed amendment to the town ethics ordinance to deal with this,
Yeah.
we'd have to send it to the state for its approval to the
Yeah.
state ethics commission.
Shoot it down.
Huh?
Or they can't shoot it down.
They can, but if I say to the general counsel, to the ethics commission, hey, Will, here's a proposal, what do you think the ethics commission would do? He's gonna have a pretty good idea. Right, I would never support that, I'd suggest you don't do it, or actually, that's not unreasonable. Not asking, you don't know.
Especially with the context you gave, that this for the state was set up to cover a lot larger ecosystem than what we're talking about in the town.
What would that say?
Oh, it would
The
just
answer
limit
to
this
this-
to the town of Chesapeake Beach.
Applies only to,
And possibly eliminating question 4. And possibly eliminating question 4, because it's just limited to the town, and the town already knows it.
Well,
what about proposing an amendment and asking, the informal more artfully worded ways? If disclosure of this information would conflict with pilot.
I think you're going too far. Something like that would have much broader ramifications. Going it to the town of Chesapeake Beach. If you guys don't like that, then I think Peter's note, I didn't have an objection to the note when I read it. Remember, the State Ethics Commission is not going to see these forms. Your interpretation of.
Yes, but this form, you're right, of course, but this information is specific, required to be local ordinance. Well, rather than batting it back and forth, the horse and the mouth. On the question, would it be limited itself? At worst, it can do no harm. Except that
They may say why. They may give us a little bit more information. Thinking of the State Ethics Commission, thinking of the council, the Ethics Commission, and maybe it's something.
write something up.
Sure, sure.
No, it was, he suggested it and.
No, but the narrow.
The narrowing, yes, right. I think that going informally to the.
All right.
You all want to, can I just go ahead and put them together and send it off, or do you want me to run it by you?
The only question, I think, I'm okay with you going ahead. The only thing I'm not sure if we finalized is question 4 in your communication. Are you also going to pose in case you narrow it, or maybe that's just the next narrow it, this question?
I wouldn't even go there. I wouldn't go there. If they say, yes, you can narrow it to the town. Leave it at that. And so you have question 4, the town knows, the person knows.
Do we remove that?
Yes, you can do that.
And we are good. Okay, perfect.
I'll do that in a couple of days.
All of November, all of December, all of January, all of
Rather get it done.
Yes.
We will know what the state ethics people think. Back to the drawing board, how we want to address the issue.
All right, moving on. Next agenda item, any additional matter for discussion? Is there any additional matter for discussion? Okay. And, we, presumably agreed to agree on a schedule for the regular, next regular meeting. One of the purposes of that meeting was to give the, approve the cleaned up, nice, professional looking version of all these papers.
So my question would be if that requires a meeting or can be done by email? My question is that iteration, the final iteration of the form, does it require a meeting or could it be done via email? That Sharon sends out, this is the email and presumably all
That I think could be done
remotely, right? So I think the question is what else would require meeting and when, right?
Well, you may want to get back together after I hear back from the state ethics commission.
Depending on their response.
I'm just trying to think what there is and may be for the commission to do. No sense meeting, just for the sake of meeting.
Exactly,
It
right.
would seem to me that it'd be more prudent to hold off on setting a meeting until there's a need for it.
I agree with that.
Well, we can leave the date open and once we have a response from the state ethics commission, then we will decide whether we need a physical meeting or not. You know, then if not, you know, are we in agreement that the Schedule H with the instructions that will fly, that we could ask this question with a loophole, you know, the confidentiality angle, and then let the finals decide whether they're subject to the confidentiality.
So depending on the answer you get, if the answer is no, we can't change it, then we go with what we have with the note that you have provided. So we are good to go. There is no further discussion.
And if they say, yes, you know, we think we will be prepared to take it to the state commission and they say, I don't know whether they will say we think, and we'll recommend the approval. I think that's what the council's office will normally do order. And if that's the answer, I would say we should schedule a very short meeting. That change that item 4.
So basically, we don't need to set a date unless there is a reason to set a date to meet, right? Is that
You know,
what we are saying?
You know, I mean, what we would do, the accountant comes back to you, maybe soon or maybe not quite so soon, but sometime. You know, you send us, you know, I got the answer, this is what it is. And then, because it would be up to me to, then, okay, folks, let me know when you can meet.
Exactly.
Well, if they say yes, then we would need to put together a proposed ordinance for the mayor and council to adopt.
Yes.
And that may require a meeting.
That may, yeah, that may require a meeting. But we can amend our questionnaire here even before our council has acted, because that'll take months.
Not sure if that would be the
Well,
right
it has to
sequence,
be
right?
introduced, there has to be a public hearing, then they have to vote.
Several-month process anyway. Sharon? For the mayor and council to, from time of introduction of an ordinance till it becomes effective. 2 to 3 months.
Once you introduce it, the next month we have a hearing.
Well, it depends what else is on the council's agenda. Last amendment could have come up for a vote a month earlier, but it wasn't scheduled because the agenda was filled with matters having higher priority. Amending the ordinance, as long as it gets amended at some point, you know, we can send out this improved pile of questions. Final agenda item, comments by commissioners and members of the public.
Have no comment.
The public had no comments. All right, we are adjourned. Always, Fred, thank you very much for being here. And,